Yes, Mr. Tyler.
My Lord, before I move on to the shape and purpose of the convention and then address the specific grounds, if I may, I'll just point to one or two factual matters missing from my learned friend's very helpful exposition of the chronology, which bear on the type of family, which bear on the exercise her ladyship undertook when dealing with habitual residence and other matters. Some of these facts are in my Lord's chronology, some are descended from the judgment, some from the statements.
I had one quick, forgive me for interrupting, I had one question about the chronology. Pages 32 to 34, it tells us that on or shortly before 9th December last, the mother made an ex-parte application to the Zambian court for a protection order. The ex-parte order, it says, is currently being contested by the father. Has anything else happened in the Zambian family court since then?
Well, yes, there have been further hearings. I think one as recently as the 23rd of February. Sorry, 23rd of March, my mistake. I don't think we have evidence from this. My instructions are that the father attended that by video link, that the hearing was told the police investigation had been reinstated, that he denied being asked to provide DNA, but that he didn't challenge the jurisdiction of the court. And lawyers, I'm not sure if that's everybody's or just my clients, were given 2 weeks to make various submissions. And a ruling date, I'm not sure in relation to what ruling, I'm told is the 27th of April.
Thank you.
But I make clear that those are my instructions. That's
yes.
not something I've agreed with Mr. Devereux and his team. So, my Lord, just some factual matters, which I'll go through fairly quickly, if I may, but just to try to redress slightly an imbalance, we would say. In May 2019, the mother travelled to Zambia for 3 weeks to make inquiries about setting up a business. In July 2019, she travelled for another 3 weeks to make further inquiries about that. In October 2019, I think this is in the chronology, she rented an apartment and travelled to Zambia further to develop business interests. The apartment, we read, was rented on a long-term basis. An architect was hired. The father, of course, having full knowledge of this because kindly he contributed to the financing of it.
Sorry, the visits for the purposes of the business. Did I get it right, 2019?
Well, yes.
Is that, okay. Right.
In November 2019, mother travelling for another 2 weeks, registering the business in Zambia, purchasing a substantial plot of land. In January 2020, she travelled for 4 weeks to continue those exploration of the business, purchasing further land and a car and employing a quantity surveyor. The pregnancy was known of course, in about the summer of 2020. From August to December 2020, this is in my Lord's chronology, the mother resided in Zambia. So she remained for a significant portion, some 4 months or something, of the pregnancy. While she travelled back at one stage, she was in Zambia in January 2021 to rent the larger villa on a 12-month rental, preparing it, she would say, as a permanent home with decorations, furniture, etc. And then in January, 28th of January 2021, she returned to the UK. She says in her statement that being the cut-off date with reference to the expected date of delivery for long-term travel. My Lords know the date of the child's birth and the subsequent health difficulties. The child and the mother visited Zambia for 3 weeks in October 2021. The mother said she registered the child with a GP at that stage. Then, of course, the mother was ill from December 21 to March 22. Even before their going over to Zambia in March, in February, the mother posted an advert for a part-time nanny in Zambia, purchased further furniture before the family arrived. During the period when all three of them were in Zambia, the father and the mother, or at least the father took part in an interview the mother was conducting for a permanent nanny. Then the 20th of March, of course, is the date the father returned, but still very soon afterwards, further of the various drip factors contributing, we say, to habitual residence were taking place. Baby development classes starting, the hire of further staff, but further to those hired with everybody's knowledge beforehand. The 11th of April, the father sending by DHL food, snacks, etc. for the child, clothes, and some of the mother's personal possessions. The 3rd of April, the WhatsApp from the father, you Lordships may have seen, if you're not planning to return, then I'll come over and see you. And this all before the 23rd of May date, when the father wrote to indicate his withdrawal of his consent. And another small error in the chronology. Of course, the message required confirmation within 72 hours of return within 10 days, rather than requiring return in 72 hours. But perhaps little turns on that, although possibly a date of retention might to some extent hinge on it. Well, if I may, I'll move on to make some remarks about the 96 Convention, but to start with general or looking at its purpose. I needn't take my lords to this section, but in almost the final paragraph of my learned friend's skeleton argument, Re J is cited in this way.
Sorry.
Very well, it's paragraph 58, pages 310 over to 311.
Yes.
As the Court of Appeal noted, it says in its final words on 310, Read J, the 96 Hague Convention is a complete code when it applies. One cannot look outside it for another source of jurisdiction. We give the fuller quote at our paragraph 34, 321. Insofar as it concerns jurisdiction, this is our paragraph 34, the whole purpose of the 96 Hague Convention, as with Brussels II revised, is to determine, as between contracting states, the state whose authorities have jurisdiction to take measures directed to the protection of the person or property of the child. We say it's an important component of the 96 Convention, and that is its principal purpose, to decide between contracting states which have jurisdiction. To which children does the Convention apply? And the answers found in several places, including at page 522, which is the explanatory report. It applies to all children from the moment of their birth until they reach the age of 18. Paragraph 311 of the report makes this point. Unlike the 1980 and the 1993 Hague Children's Conventions, the child does not have to be habitually resident in the contracting state to fall within the scope of the 1996 Convention. For example, a child may have her habitual residence in a non-contracting state, but still fall within the scope of Article 6, refugee children, internationally displaced children, or those whose habitual residence can't be established. Article 11, measures in case of urgency, or Article 12, provisional measures of the 1996 Convention.
So
I'm so sorry,
I don't know where you're reading from.
It's page 522 of the authorities bundle.
Sorry.
My Lord, this is the explanatory report. Sorry, this is the practical handbook. And I was reading from paragraphs 310 to 312. I was going to go on to 312, which forms the basis, presumably, of the Court of Appeal's comments in Re J. However, it should be noted that where a child does have her habitual residence in a contracting state, the rules of jurisdiction contained in Chapter 2 form a complete and closed system which applies as an integral whole in contracting states. Therefore, a contracting state is not authorised to exercise jurisdiction over one of these children if such jurisdiction is not provided for in the Convention. And this, we would say, gives perhaps the slightly more detailed description of my Lord Moylan's shorthand of those cases to which the Convention does and doesn't apply. That mirrors Lagarde at page 561.
Sorry, are you reading a lot into the last sentence of 3.12? Because what it really means, a contracting state is not authorised under the Convention to exercise jurisdiction.
Yes.
Right, okay.
I'm not.
And it could also, as regards other contracting states,
Yes.
a contracting state is not authorised to exercise jurisdiction
Yes.
under the Convention.
Yes. I accept both of those. And my Lord, I was moving on to page 553. Sorry, 561, which is internally 553. 561. Paragraph 37 seems to be the source of the practical handbook quotation I've just noted. Paragraph 39 is also relevant. This is Professor Lagarde dealing with Article 5. Article 5 is based on the supposition that the child has his or her habitual residence in a contracting state. In the contrary case, Article 5 is not applicable, and the authorities of the contracting states have jurisdiction under the Convention only on the basis of provisions other than this one. But nothing, and this is a point the Lords have made to me a moment ago, nothing prevents these authorities from finding themselves to have jurisdiction outside of the Convention on the basis of the rules of private international law of the state to which they belong. Well, as I'm going to, with your permission, take you in a little more detail to a couple of sections of Lagarde in a moment. Just before I do, I wonder whether this is the point at which to make this observation. In the Derbyshire case, on which so much store is put by my learned friend, Mrs Justice Leven seems, for a number of reasons, to distance herself from what we would say are pretty clear observations in the Lagarde report, and does so inter alia with reference to the Vienna Convention on the interpretation of treaties. Her Ladyship cites Article 31 of the Convention, but doesn't go on to mention Article 32. These aren't separately included in the bundle, but my Lords will find them at page 454 of the authorities bundle. And I know these are articles with which the court will be well familiar.
Don't assume anything, Mr. Turner, certainly in my case. Which page?
454.
Yes.
Now, it's lucky for us that, lucky for me, that Mrs Justice Bennett, if I correctly have her judicial title in Australia, annexed this to her judgment in Bunyan and Lewis. But one sees Article 31, which Mrs Justice Lieven prayed in aid, effectively, of not treating Lagarde as authoritative, which requires a treaty to be interpreted in good faith, with the ordinary meaning to be given, to treat it in their context and in light of its object and purpose, and then allows the context to comprise, in addition to text, including preamble and annexes, any agreement relating to the treaty between the parties, any instrument made by one or more parties, and within the context, any subsequent agreement, any subsequent practice in the application of the treaty, and any relevant rules of international law. And it looks from the Derbyshire judgment as though her ladyship doesn't consider Lagarde to fall into those categories. We would say he probably falls into 3B. But in any event, Article 32, supplementary means of interpretation, recourse may be had to supplementary means of interpretation, including the preparatory work of the treaty and the circumstances of its conclusion, in order to confirm the meaning resulting from the application of Article 31, or to determine the meaning when the interpretation according to Article 31 leaves the meaning ambiguous or obscure, or leads to a result which is manifestly absurd or unreasonable. In relation to petuatio fori, we would say that either Article 5 makes it clear that it does not apply, or at the very least, given quite how many eminent judges have held that to be so, the meaning is ambiguous or obscure. And we would say that the Lagarde report, given that it describes in such detail the reasons why the Hague Conference settled on the final text it did, certainly represents evidence of, quote, the circumstances of the conclusion of Hague 96. And if my lords, I know this is remotely binding on this court, but if my lords turn back to page 410, please. One can see at paragraph 86, and this is the body of the judgment in Bunyan and Lewis, that is the conclusion to which Bennett J. came in relation to the Lagarde report. And then at paragraph 87, the practical handbook, drawn up as it was by the Permanent Bureau, she says is comprehensive and informative. It can't be said to fall within Article 31.3a or b or 31.2 of the Convention. It does represent a consensus of informed opinion, which can lend support and guidance to one's own interpretation of the Convention. And it is in this way I refer to it for those reasons. It's a bird's eye view into the way in which the Permanent Bureau considers the Convention was intended to, does, and can operate. And parenthetically, I note that in the case I referred to earlier, Re-Ex, in which Lord Justice Moylan, together with Lord Justices Baker and Newey, turned their collective minds to the meaning of Article 61 of the Brussels II revised regulation, to the extent that that involved interpretation of Article 52 of this convention, which is certainly a difficult article. Regard was specifically had, first of all, to Lagarde's explanatory report, and when even that didn't make matters entirely clear, to the practical handbook. So authority in this court for using those two resources in the way that we say they ought to be used. So if I may, I'll return, if I started there, to my skeleton argument at paragraph 37. Perhaps 36, first of all. Lords, I think it's easier for me to refer my lords to extracts that are set out here rather than
Yes.
to plough through
Yes, it is.
that difficult and closely typed report. The new convention was intended to eliminate, in principle, all competition between the authorities of different states in taking measures of protection. And secondly, we say it forms no purpose of the objective of the convention to prevent contracting states exercising domestic laws where it doesn't apply. I think we agree with Mr. Devereux on that. And the last line of that extract: nothing prevents these authorities from finding themselves to have jurisdiction outside of the convention on the basis of the rules of private international law. So paragraph 38 is where we make the assertion that it's where a child doesn't have habitual residence in any contracting state that the convention doesn't apply. It should have to be slightly broader than that, because of course there are those very few articles in which explicitly a child who's present in a contracting state, albeit not habitually resident, would be the subject of jurisdiction of a contracting state. There's a list of children who fall outside the scheme, or to circumstances outside the scheme, that we say recourse to the domestic jurisdiction could be had.
Is it more accurate to say that where a child has never had habitual residence?
Well, not quite, because, for example, jurisdiction of a child in a neighbouring country, a non-contracting neighbouring country, present but not habitually resident, will be the subject of a court's jurisdiction if they're there because of international disruption or the like. But those circumstances, we say, in which jurisdiction vests in a contracting state in relation to a child who is not habitually resident are very, very few. And of course, question, does Article 7 apply in those circumstances, given that the child was, by definition, habitually resident and isn't, by definition, in the context of this case, habitually resident. My Lord, it looks as though reliance is placed on Hackney and similar cases for the proposition that the convention applies in relation to effectively jurisdiction disputes between contracting and non-contracting states. We say that is to misconstrue those cases. I think we've confused ourselves in this paragraph. Hackney, of course, is the Tunisian case, and Warrington is the Gabonese case, but the same applies to both. Children hailing from other parts of the world and from non-contracting states found themselves both present in and habitually resident in this country when the threshold circumstances of Section 31 of the Children Act were said to have arisen. And in those circumstances, Mr. Justice MacDonald found that the English court had jurisdiction to deal with them. But that's not because his lordship was determining a dispute between this country and any other. It was simply that on the simple application of the fundamental guiding principle of Hague 96, there was a child who was habitually resident in this country at the point that the court had to decide whether to exercise jurisdiction. And so one doesn't have to look to any other part of the world or international relations. As long as there's no competing Hague jurisdiction, for example, they've been wrongly removed here from France, then self-evidently Article 5 serves to give the English court jurisdiction. But that isn't to import any extra conventional sense to the convention. They're simply to apply absolutely straightforwardly Article 5. And my lords, I've read the paragraphs that...
Sorry, I didn't quite get... I think I understand what you just said. You just postulated a situation where a child is habitually resident in the UK and there is no competing convention country.
Yes.
I mean, in that case, the UK would have jurisdiction, not because of Article 5.
Because of Article
Why because of Article 5? Why not because of our own domestic law?
Because Article 5 says in terms that the country of the child's habitual residence.
But I thought you just said that Article 5 is designed to resolve the conflicts between contracting states, and where there's no conflict with another contracting state. Surely it's only because we start with our own domestic law.
Well, no, the fundamental guiding principle underlying Hague 96 is that it is the contracting state of a child's habitual residence who have jurisdiction for that child. And in the vast majority of those cases, that will be uncontroversial because the English child who's always lived in England, habitually resident here in relation to the English courts exercise jurisdiction. But it's not nationality based, it's habitual residence based. So that's the starting point of Hague 96. In the knowledge that there will be other potential difficult situations, the following articles, 6 to 14, set out the way in which any potential conflicts can be resolved as between contracting states. But the reason for Mr. Justice MacDonald having jurisdiction in relation to a Gabonese child who is habitually resident here is because Article 5 says so. And under Hague, that is the founding part of our jurisdiction.
Well, with respect, I think you're starting at the wrong point. I think you should start with Section 2 of the Family Law Act. Because the Family Law Act sets out when a court in England, where certainly in respect of Section 11A order, has jurisdiction.
Well, yes.
The first bit, it has jurisdiction.
That's my question.
Oh, see, I'm so sorry.
Yeah,
yes.
that was my question, essentially.
That it has jurisdiction under the Hague Convention. So that's why we're looking at the Hague Convention.
Yes. I'm so sorry. I thought Moylan was talking about the residual domestic jurisdiction if Article 5 didn't apply.
No.
It's the starting point.
Exactly, but why did we just start with our own domestic legislation? So the answer is yes.
I misunderstood. So yes, the Family Law Act dictates the circumstances in which Section 11A, 11D orders, for example, can be made. Right. Reason number one, jurisdiction under Hague. Reason number two, Hague doesn't apply. Question, what does that mean? In which case, the various other criteria, which then chimes with, well, that's what then gives rise to the need to look to Hague to see whether jurisdiction vests in this country through that. But secondly, we would say that the Hague doesn't apply part of that has to be seen in the context then of the circumstances in which Hague would or wouldn't apply, which I hope I've been setting out. So, for example, if a child is habitually resident in France, this country wouldn't have jurisdiction under Section 2 of the Family Law Act by virtue of the Hague Convention. But you couldn't say, but Hague doesn't apply. Therefore, we look to our own national jurisdiction. Hague does apply, and Hague applies not to give us jurisdiction. That is different to a case in which a child is completely outside the scope of Hague.
Speaking for myself, I don't understand that. Because you're saying Hague, paragraph, the words in 2.1b, the Hague Convention does not apply even when the Hague Convention does not apply to give this court jurisdiction. So which is rather denudes paragraph 2.1b of much effect.
Well, the opposite, though, would be on my French habitual residence analysis. If Hague doesn't apply, means Hague doesn't apply to give England jurisdiction, then the satisfaction of the 2b2 criterion would be enough, which would mean that we would have jurisdiction if the child was present here, which can't be what's intended.
Well, how do you deal with matrimonial proceedings?
Well, in the same way, my lord. But the
So your submission is the Hague Convention applies to change the meaning of our domestic law, the effect of our domestic law. Is that it?
no, the meaning of the Hague Convention doesn't apply. Doesn't mean in domestic law. The Hague Convention doesn't give England jurisdiction. But the Hague Convention doesn't apply to that child. Because otherwise, wouldn't there be a conflict of jurisdiction in every case in which the child was present in this country but habitually resident in another contracting state?
Okay.
Well, if I may, back to our skeleton where we set out our interpretation of the scheme underlying Hague. We make reference then to the other exceptions or exceptional articles of jurisdiction. 6, 7, 8, providing exceptions to Article 5, 9 and 10 for transfer, 11 and 12 for urgent or provisional measures, and then Article 13, and I've already set out what we say about that, which is Article 13, is aimed at dealing with potential conflicts of jurisdiction within the Hague countries. Because it would have no meaning otherwise, but it's entirely conceivable, and refer to at various points that it won't be entirely clear, and there's no autonomous court of arbitration to decide as between each of us. It's perfectly conceivable that more than one Hague country may be a contender for habitual residence, and Article 13 provides the means of ensuring that two Hague states don't contemporaneously exercise the full welfare jurisdiction in relation to a child.
Have you concluded your submissions on the meaning of the words "the Hague Convention does not apply"?
I take it from the question. I probably oughtn't to have done my lot.
Well, if you just take the Hague Convention on its own, it applies to all matters of parental responsibility.
In terms of the scope of the subject matter of potential
Yes.
cases, yes.
So is that what that means? So is when the court's dealing with any matter of parental responsibility?
Well, no, that would mean that Hague does apply in every conceivable case.
Right.
And so it doesn't.
So it's not scope.
No.
So it doesn't apply in what sense then? In respect of jurisdiction?
Well, in the sense, perhaps I should move on to this, in the sense contemplated, for example, by Professor Lagarde.
Well, that's
So-
not. That's not that's opaque to use the word.
Well,
What do you mean in a sense?
well,
Used by Professor Lagarde.
let me.
Because you see, if you go through 2.1b and you go to section 2.1b2, you go to section 3, that gives the court jurisdiction if the child is habitually resident in England and Wales.
Well, yes, but that's the problem.
Well, but this is in the context that the Hague Convention doesn't apply. But on your case, it always applies, doesn't it, if the child's habitually resident in England and Wales? So it's a completely circular provision.
So, section 2. A court shan't make an order unless it has jurisdiction under Hague.
Yes.
It will have jurisdiction under Hague if the child is habitually resident here, unless, for example, the Article 7 prohibition or extension of jurisdiction in, let's say, France has been activated. But if it has been activated, that wouldn't be a reason to go on to say, well, Hague doesn't apply, So we'll see whether the criterion in 2b2, which is section 3, is satisfied. Because that would be, as my lord said, mere presence in the country.
Well,
so it must mean,
yes.
it must, given that section 3, 1b, goes absolutely, entirely against the founding principle of Hague 96, i.e. jurisdiction resulting from mere presence, then it must mean, we say, section 2, 1b, that the Hague Convention does not give jurisdiction to a Hague Convention country.
Including England and Wales?
Well, if it gives it to England and Wales, then we don't get that far because 2.1a is satisfied. (2.1a).
Sorry, so if you look at 3.1a, 3.1a gives the court jurisdiction, the court in England and Wales jurisdiction, if the child is habitually resident in England and Wales.
Yes.
In what circumstances will that apply on your case?
That would apply. Well, my lord, arguably it's difficult to foresee a circumstance when it would do.
Can I try something, and I'm perfectly prepared to be shot down in flames, so don't hesitate in the slightest, which comes from my more usual area of expertise. Is it possible to say that the Hague Convention applies as between contracting states? Because if you don't sign the Hague Convention, it doesn't apply to you. That's sort of, I would have thought, rule 1 of conventions. If you have a question as between contracting states, you have to, the English court can only take jurisdiction if it does so in accordance with its international obligations under the Hague Convention. If you have a question as to jurisdiction as between the UK and a non-contracting state, the Hague Convention does not apply, in which case you need to go to the provisions that under section 2 for when the Hague Convention does not apply. And section 3 then tells you the test you need to satisfy. I mean, is that not a sort of simple way of looking at it?
Well, it's a simple way of it. It doesn't get round the fact that Article 5.1 is terms very deliberately in holistic terms.
But it's only binding as between convention states. It says nothing to somebody who hasn't signed the convention. And so how can, if there's a question as to this, the whole purpose of the convention is to resolve jurisdictional conflicts.
Well,
this bit of it that we're looking at.
That's the second purpose. The first purpose is to define who has jurisdiction.
Yeah, but only in a situation, you only need to have that definition as between contracting states where there's a potential conflict. Otherwise, you leave it for each member state. I mean, the convention can't define jurisdiction as between a convention state and a non-convention state by definition. How can it?
Well, it can define it in relation to whether a convention state is entitled vis-à-vis other convention states to exercise jurisdiction over even a non-convention child. And that's the point made in the Lagarde report about the consequence of measures if they're taken under one of the exceptional articles of the convention as opposed to under domestic law. But my lord's analysis would have then convention jurisdiction vesting in a child if they were unequivocally an English child, if there was a potential dispute between England and France, but if there were a dispute between England and Gabon, for example, then jurisdiction wouldn't vest by virtue of the clear words of Hague Article 5.1.
Because Gabon is not a party to the convention. So Gabon is over what's got to do with us.
Well,
And why would the UK be applying a convention which Gabon is not a party to resolve the question?
well, just as with Brussels II revised, this convention governs jurisdiction in relation to all children who fall within it. Not why would Gabon give a question in those terms, but the same rhetorical question. Why would Gabon be bound by paragraph 3.1a, or section 3.1a of the Family Law Act, a statute, domestic statute of a country in relation to whom they have no bilateral or multilateral obligations? So these simply define that the domestic law defines for domestic purposes when England has jurisdiction. Conventional law defines for convention purposes when states do. But domestic law, as Moylan points out, section 2, before we get to look at the separate domestic provision, founds jurisdiction primarily in Hague terms. We're just going back a moment before our exit from Europe. Section 2.1a would have been under the regulation for the Hague Convention, i.e. Brussels revised. But unless I'm very much mistaken, it was never said that in relation to a child who wasn't either English or European. Brussels II revised didn't form the founding basis of domestic children law jurisdiction. It just so happens that we're looking at this all over again because having Brexited, we are grappling with a new convention. But with, so far, different than Article 7, so far with starkly similar terminology.
Sorry, this may be an even more naive question. Take the case of a child that has lived in England all its life. There's no international element in the case at all. The source of jurisdiction to make orders under the Children Act is Children Act itself plus the 1986 Family Law Act, section 3.1a, isn't it? Habitually resident in England and Wales.
Yes, it's section 1.1a which founds the which defines the
No, you have been asked, I think, quite deliberately about 3.1a.
Yes.
Not
1.1a is the definition section, and 2 says a court in England and Wales shall not make a 1.1a order with respect to a child unless ... the condition in section 3 of this act is satisfied. Section 3 is either habitual residence or presence in England and Wales. Let's leave Scotland and Northern Ireland out of the discussion for the moment. And the case is not excluded by subsection 2. So isn't that the basic source of the jurisdiction to make orders outside matrimonial proceedings? If it's matrimonial proceedings, then section 2a.
Well, with the greatest respect, our short answer is no.
Right.
Because section 2.1a comes into play before my lord comes to section 3.
Why has the in the example I've given of a child that has been in England all its life, say a 5-year-old, why has the Hague Convention got anything to do with it?
Because England and Wales, or the United Kingdom, along with all the other signatory countries, signed up to a universal system of deciding who has jurisdiction. And the founding principle for that is habitual residence. So my lord's example, a child who's never left his village, let alone the country, will still be within this court's jurisdiction because Hague 96 says it does. A, because Hague 96 represents our international obligations, but B, because a plain reading of Article 5 brings that child within Section 11A and then, or rather, Section 21A.
So you read the Hague Convention as a substantive harmonisation of substantive law as between its contracting members, not just a convention to resolve conflicts, potential conflicts between contracting members.
But it's to agree who has jurisdiction, even where there's no conflict. And secondly, to provide from Article 6.
So you say it provides a substantive measure of law.
Well, only substantive because of Section 21A. But
It's odd because the objects of the convention don't include harmonisation of sort of law. It's to determine the state whose authorities have jurisdiction. But surely that is in the context of wishing to avoid conflicts between their legal systems in respect of jurisdiction, applicable law recognition, etc. Right at the top. I mean, it doesn't say we wanted to harmonise our jurisdiction provisions. It said we wanted to avoid conflicts between our legal systems.
Yes, but the first object my Lord read out is decide who has jurisdiction, not which of two competing states have jurisdiction.
Well, no, actually the first thing that comes is wishing to avoid conflicts between legal systems in respect of jurisdiction. Yes. And then you read down to Article 1. I mean, I think the point that's being put, certainly I'm trying to put without speaking entirely for myself, is that you start with our domestic law and do you not have to read the references to the Hague Convention in the context of what the Hague Convention is trying to achieve? And if it's not resolving a conflict between Hague Convention signatory states, then I don't for myself at the moment see why you troop off to look at the Hague Convention as opposed to just looking at Section 3. I mean, it's basically, act in accordance with Hague, where Hague is relevant for the purpose of resolving a conflict or potential conflict of jurisdiction, but you don't have to go to Hague. Why don't you just go to Section 3?
Well, because that's not what Hague says. It's not what the FLA says. It's not, on my understanding, how these courts, right up to the Supreme Court, interpreted mirror provisions under Brussels, and it would be to act in a way in which other states don't in relation to their interpretation of Hague.
But the vast majority of cases we've been looking at are ones which resolve issues between contracting states.
Well, yes, I might confess to being slightly wrong-footed. I hadn't understood it as any part of my friend's case to say that a child who wasn't the subject of an international conflict was not one jurisdiction in relation to whom was granted via Hague. Am I wrong? Excuse me. I'm very helpfully reminded that the prospect of conflict arises not just at the point of jurisdiction, but at any other point. If measures in relation to a domestic child are taken pursuant to our domestic jurisdiction rather than Hague, then they wouldn't be enforceable. And of course, the second purpose of Hague, and look at its long formal title, but relates to recognition and enforceability. And again, in terms, regard if one accepts the report, says in terms, as does the handbook, that measures taken outside Hague jurisdiction, but subject only to domestic jurisdiction, whilst a member state is perfectly entitled to do it, they will not be recognised or enforced in a foreign country. So back to the analogy, the purely English living English child in relation to whom this court makes a contact order would not be the beneficiary of that order being enforceable or recognisable under Hague in a different country, which would be to ignore or to cut completely against. Again, one of the fundamental founding purposes of this convention, following as it does on previous similar conventions.
Taking the present case, your argument is that the Hague Convention doesn't give jurisdiction to England and Wales because the child was not habitually resident in England and Wales at the relevant date.
Yes.
And the question I have is, if that is right, in other words, if your interpretation and application of the provisions of the Hague Convention is right, why don't we then go to 2.1b?
Oh, yes, quite. I agree entirely. That's exactly the route which was taken in H&R by Mr. Justice Peel.
Right.
But there has to be, the stage at which I'm hesitating is to acknowledge that Hague doesn't apply in all circumstances in which a child is habitually resident in this country. But Moylan is entirely right. So
doesn't apply. Sorry.
The suggestion from a Lords was that a child who's not the subject of an international dispute, but who is unequivocally habitually resident here, jurisdiction of that child doesn't vet in English courts via Hague, but via domestic, non-Hague means, route. I can't accept that for a moment. I accept my Lord Justice Moylan's suggestion or point, which is that that Mr. Justice Peel set out, which also accords with the Guard. So assume for a moment, I'm going to persuade my Lords that the relevant time for determining habitual residence is the time of the hearing, of the decision whether or not to make the measure. On Mr. Justice Peel's analysis, question 1, does Hague give jurisdiction for that? So at the point that I'm making this decision whether or not, for example, to make a Children Act or Hague inheritance restriction return order, is the child habitually resident here? If so, I can make it. If not, then the child falls outside, because we're looking at non-conventional cases, falls outside the convention, so I can have regard to domestic law. Domestic law, section 2.1b, would say Hague doesn't apply, so is there jurisdiction under the Family Law Act, i.e. by virtue of habitual residence or presence at the relevant time being the date of seizure under the FLA. It would, a further consequence of the analysis which my Lords suggest, be then that perpetuatio fori applies in relation to children who at the point of the court having jurisdiction weren't the subject of international dispute, but wouldn't apply in cases where they were. The whole import of our case, and we rely, as I say, on a raft of authorities, if I have time I'll take the court, is that under Hague, there being no perpetuatio fori principle, it's at the time of the decision that the court has to wrestle with the question of jurisdiction via habitual residence. If the non-conflict domestic child if the court has jurisdiction over him or her via the Family Law Act but not Hague, then it'll be the point of seizin at which jurisdiction, habitual residence is assessed, which would then create the most bizarre scenario and the antithesis of the unifying situation anticipated by our membership of the Hague Club.
But why is that? As between members of the club, in a sense, you can ask the question at any stage you want, provided that all members of the club have a consistent approach and there's no black hole into which the child might drop in between. But as regards a situation where you've got a contracting state and a non-contracting state, there's an inevitable problem because by definition you haven't got another state that is contracting. So why wouldn't you assert jurisdiction, allow this court to assert jurisdiction at the earliest time? Because there won't be another contracting state involved. I mean, you as I understand it, the point you just made is that the difference in timing makes no sense, but you're dealing with two different situations. One is as between contracting states where there's a complete system which could transfer jurisdiction between contracting states at any time that they have agreed, whereas the alternative scenario is you've got no contracting state on the other end of the problem. So why couldn't there be a different answer to the problem?
Well, it would create absolute turmoil at the coalface with satellite litigation in relation to which there is a conflict or not. All that we needed would be for somebody to say, well, I suggest that the Democratic Republic of Congo has jurisdiction because we went on holiday once. And the point of, it's a silly example, but the point of seizing would no longer be the point of jurisdictional determination, but something else. Well, more broadly, the reason we say it applies to every child is because that's exactly what the handbook says, and exactly what the Guard says, exactly what we would say is, and
the Hague Convention applies to every child
who falls within the scope. So turn it around the other way. Article 5, the terms thereof, the judicial or administrative authorities of the contracting state of the habitual residence of the child have jurisdiction to take measures directed to the protection of the child's person or property. Now, if it's suggested that that in fact only applies where there's natural or potential conflict in relation to jurisdiction, then we would say that article is manifestly misdrafted. Turned around another way, in Vienna Convention terms, what is the meaning of that? It must be that regardless of nationality, which is specifically excluded in this convention as being a ground of jurisdiction, unlike previous conventions, regardless of presence, regardless of domicile, another potential ground, it's the habitual residence in the contracting state that gives the contracting state jurisdiction. And if that's right, then section 2.1a would bring the totally domestic English child well within the scope of that.
So that leads to a result where if the court has jurisdiction under the Hague Convention, then you say the critical date is the date of the
Determination of the measure.
Whereas if it doesn't have jurisdiction under the Hague Convention, then the critical date is the date of application.
Yes. Well, I wonder whether...
But I still don't understand, because if you say it's the date of the hearing, and the court decides, I don't have habitual residence now, so the Hague Convention doesn't apply, you go back to 2.1b.
Well, yes, unless...
So you end up with the date of the hearing, the date of the application.
Yes, if it's a non-Hague conflict. Yes.
Yes, so that is the case we're dealing with, which is a non-Hague
Yes.
state. So you accept, as I understand it, that based on a finding that of habitual residence at the date of the hearing, but you would then go and see whether you had a jurisdiction based on habitual residence as the date of the application.
Yes, which is why it's so important whether the application is a Section 11A or 11D order, or whether it falls outside. Which again is exactly looking, for example, at Mr. Justice Peel in H&R, because his lordship may have a more authoritative voice than I do on this. So this is at page.
Well, sorry, before we go to Mr. Justice Peel, I just put this question. Suppose that in the present case, the father flies back to the UK on the 20th of March, and suppose the very next day he had lodged an application in the family division. Which section would apply?
The court would, at the date of deciding whether to take the measure in question, so final hearing, determine whether at that date the child was habitually resident in this country.
But how can that be right? If the application was lodged on the 21st of March, it could not, I think, conceivably be said that on that date the child was habitually resident in Zambia. So why doesn't the court simply have jurisdiction on the basis that on the relevant date, that is the date of the application, the child was habitually resident in England and Wales?
Because that would fly in the face of the interpretation of the Convention of most Brussels countries, Australia, Austria, the decisions of 4 or 5 division judges, but wouldn't, perhaps more importantly, wouldn't properly represent the wording of the statute, incorporating as it does the Convention and the plain wording of Article 5.1.
Well, that's something you're going to have to come to, because it is, as Mr. Justice Leven said, it's slightly unsatisfactory that nobody knows whether the court has jurisdiction to make substantive orders until the final hearing. You know, you can make interim care orders, you can make contact orders. You have to have jurisdiction to make an interim care order and make a contact order during the course of proceedings. But you don't know whether or not you're going to be able to make a full child arrangements order until the date of the hearing. It's a very odd position.
It is. Well, just to go back one stage, and I needn't ask my lord to turn to this, but Mr. Justice MacDonald in the Hackney case described the English statute we're looking at in this way. The Family Law Act 86 has been described as a, quote, complex.
Sorry, where are you reading from?
I'm reading from page 132 of the Authorities Bundle, my lord. Paragraph 25. The 86 Act has been described as a, quote, complex, much amended, and thoroughly unsatisfactory statute. That's the High Court in Reed G. Certainly, having to consider the terms of the Act is apt to bring to mind the saying, first attributed in one of its early versions to Sophocles, that, quote, whom the gods would destroy, they first make mad. Without conveying on my lord's status of deity, I feel quite close to the first of those difficulties. But the Act is problematic, and the consequence that my lord, Justice Moylan, refers to is problematic. Look, for example, at the Australian Act that gives voice to their 96 Hague obligations. It defines in much simpler terms, we see it in the Australian cases, how and when jurisdiction is to vest. But we would say that we can't, we, the English courts and judicial system, can't interpret a Hague Convention in a particular way because we have patently unsatisfactory domestic legislation. There must be an autonomous meaning applied throughout the states. I will be told if I'm wrong, but to suggest that Hague doesn't apply to a national child absent an international conflict of jurisdiction would make us an outlier in relation to every Hague state and, with the analogous provisions of Brussels, every European state. The 86 Act is our way of giving effect to our obligations, and not a particularly good one.
On your case, you could start proceedings on a whim, and everybody would have to say, wait, let's wait until there's a substantive hearing for the court to decide what order to make. Like
Whether it's got jurisdiction.
whether it's got jurisdiction. That would seem rather an odd consequence.
Well, it would apply only to a case in which a child was not in the jurisdiction at the time, but was in a non-convention state.
No, a child comes here on holiday. Someone brings an application to the Children Act. And there's a contest. Well, we have to wait 6 months because of the delays in the court to have a substantive hearing. And by then it's argued, oh, well, the child has now become habitually resident. Forget about the commencement of the proceedings. We have now acquired jurisdiction. That would be an odd consequence of your interpretation.
Well, that's not dissimilar to the Derbyshire case, in
No,
which
it has
the children...
similar features, and I'm echoing
Yes.
some of the things said by Mr Justice Lever.
Yes, but the consequence of that is that her ladyship decided that the court didn't have jurisdiction, but that it ought to exercise it, and so relied on the transfer provisions of the convention to ask Spain if they would agree to the transfer of jurisdiction.
But how do you get around the evident unsatisfactory nature of the issue of jurisdiction fluctuating and not being determined until the final hearing, where there might have been lots of hearings in the interim? There might be an adjourned final hearing. What about the Court of Appeal? Comes to the Court of Appeal on appeal, situation's changed, and the Court of Appeal is proposing to set aside and make its own order. Can it only do so if it again considers the issue of habitual residence?
Well, that is the consequence of the absence of perpetuity of fore.
It depends on what you mean by that.
Well, it's a consequence of the fact that the English court loses jurisdiction, one way or the other, when the child ceases to be a habitual resident within its bounds. And we're told by both Lagarde and by the handbook what the consequences are. If habitual residence is lost to another contracting state, the same unsatisfactory scenario arises. The English court loses jurisdiction, so it presumably should cease to act. But, and my lord asked about this earlier, about the purpose of the transfer provisions, it can do what Mr. Justice Lehman did, and said to Spain, please can we have jurisdiction.
So on an appeal, if habitual residence changes during the course of appeal, the English court would lose its jurisdiction to determine the appeal.
Well, I've not given thought to that. I wouldn't have thought that an appeal was a measure within the description of the convention. But was unsatisfactory or not, the 86 Act difficult to understand or not, those problems arise whether the second state, so we're clear, the state in which a child acquires habitual residence, having lost it in this state, that would apply whether that was a Hague state or not.
Can I just ask a broader question? Given your agreement that on this case, in a sense, the decision as to habitual residence at the date of the hearing doesn't matter, because if the court decided it had jurisdiction, it retained it. If the court decided the children were no longer habitually resident, or child, sorry, you go back to the date of the application. On this case, the relevant date is the date of the application.
Yes. But in this case, this is the point. In this case, domestic legislation wouldn't give jurisdiction on the basis that this isn't a 1-1A order.
Well, that's
But in any event,
that's why I raised the issue. There seemed to be confusion about the use of the word inherent jurisdiction. Either inherent jurisdiction is used to found jurisdiction, or you're using the Family Law Act. I don't think anybody was suggesting, and this wasn't how it was argued in front of Mrs Justice Arbuthnot, that the inherent jurisdiction was being used to found jurisdiction. In other words, the exceptional jurisdiction based on citizenship or nationality. Nobody was arguing that.
no.
Right. So it has then to be an order within the scope of the Family Law Act.
Yes.
It has to be. You were just saying it wasn't.
It has to be for jurisdiction to be founded.
Yes. So it's a 1-1A order. It's a parental responsibility order. It says, as was decided in, is it ANA or Reach A, that an order of ordering the return of children can be either an order under the inherent jurisdiction or the Section 1-1A order. And if nobody is asking for the court to exercise its exceptional inherent jurisdiction, it's inevitably a Section 1-1A order.
Well, we would say not if it's very clear from the application and the form used that this is an application for an inherent jurisdiction, their return order.
Where is that argued below? That this depends on the exceptional exercise by the court based on some compelling circumstances.
Well, it's
Why was the judge even looking at the Family Law Act? Why was the judge looking at 1996? If it's an inherent jurisdiction, 1996 doesn't apply at all.
well, I'm not sure I would agree with that. An inherent jurisdiction parents patre order would be separate, but an inherent jurisdiction bear return order would be.
Based on what jurisdiction?
Well, based on Hague.
Based on habitual residence.
Yes.
But if it's not a Section 1-1A order, we're not within the Family Law Act at all.
No. Well, I wonder if it would be helpful to look at the reasoning of Peel J on effectively
Yes.
The same issue.
Sorry to answer the questions, but I thought it was accepted by both sides that we were looking at the jurisdictional provisions of the Family Law Act.
Yes.
They applied in this case. Right. Sorry. I'm taking them.
So we're on to page 217. One sees in the head note at 218 the essential reasoning. But it's more helpfully set out at paragraph 34 at 225. The first question is the date at which habitual residence falls to be considered. Is it as the mother submits the application, or father the date of the hearing? If the latter, there's an obvious concern, and his lordship sets out the concern that my lord's expressed. Paragraph 36. His Lordship refers to the part of the explanatory report to which I would have been taking my Lords in due course, which reminds the reader that it was the courts of 4 countries, including Britain, that there should be a perpetuatio fori provision, and that was overwhelmingly rejected by the conference. A plain reading of the passage says Mr. Peel and
So sorry, which
paragraph 37, my Lord.
87.
37.
37.
Sorry, if you go through what is said in the Lagarde report, it says we have the proposal from the common law jurisdictions, which is rejected. We then have certain delegates negative to the very principle, while other delegations thought it would be more simple for the convention not to say anything on this subject, therefore abandoning to the procedural law the decision on perpetuatio fori. First opinion appeared to be more exact, not acceptable. So if you look at what happened during the special commission leading to, or the commission leading to the, it looks as though there was quite a divergence of views.
Well, it looks...
We have the rejection of the clear, we have the proposal that it should be automatically, which doesn't seem to have been accepted, and then other delegations saying leave to procedural law. So it looks as though it was sort of left vague.
Well, I'm not sure, my Lord, because the perpetuatio fori delegation was defeated by a strong majority, and of the 2 remaining views, Lagarde says the first opinion is the more exact. In the case of a change of habitual residence from one state to another, and it's not acceptable to leave it to the interior of the scope. Mr. Peel agrees with that plain reading suggests that a change of habitual residence during proceedings leads to a change of jurisdiction from the outgoing contracting state to the receiving contracting state. Lordship expresses some misgivings about what that means, but then the misgivings have to be laid to one side, because he goes on to the other part of the report I was going to take my Lordships to, which sets up, on the other hand, in the case of a change of habitual residence from a contracting state to a non-contracting state, Article 5 ceases to be applicable from the time of the change of residence, and nothing stands in the way of retention of jurisdiction under the national law of procedure. Taking that first sentence, that is what I have inexpertly been trying to articulate, that notwithstanding a potential conflict or anything else, according to Lagarde, and I would say the members of the conference, in relation to any child, is Article 5, whilst they're habitually resident, that found jurisdiction. When they move, Article 5 either means jurisdiction moves with them, if it's to a contracting state, or it means that Article 5 simply ceases to apply anywhere in the world if the child moves to a non-contracting state. And that then is the scenario set out in Lagarde, which Peel J agrees with, that it's at the point that there is no Hague state to receive the outgoing child by virtue of his habitual residence, that Hague ceases to apply, and that national rules of jurisdiction come into play. The relevant national rule in our less than elegant statute being Section 2.1b, giving rise there to Section 3. Again, which is why, given that our statute does have, for the residual jurisdiction of Section 3, effectively perpetuatio fori, whereas explicitly Hague doesn't, we have the unsatisfactory situation of having to look at habitual residence at different dates. Lords, we say, and it may be helpful, first of all, just to continue to look at Justice Paul's decision. In paragraph 40, his Lordship accepts the plain reading of Lagarde and its import. this effectively is the answer also to the Article 6 point, that the peril, the mischief for the child, if the abduction and or change of habitual residences to a Hague state is dealt with by Article 7 retaining jurisdiction. If it's to a non-Hague state, one falls back on domestic jurisdiction, and provided that the child was resident here habitually at the point of seizing, then Section 3 gives this court jurisdiction. So it's only in the very unusual case of abduction to a non-Hague 96 and non-Hague 80 state, and when habitual residence has passed before the date of application in this court, sorry, in the English first instance court, the mischief arises. Now, on Mrs Justice Arbuthnot's ruling, that is what's happened here. Her ladyship said that habitual residence had passed even before the point of application. Hard cases make bad law. It will be a rare circumstance in which the abduction or retention is to or in a non-Hague 80, non-Hague 96 country, and in which habitual residence passes even before seizing within the English court. And if that's a problem, that's a matter we would say which should be grappled with at government level rather than court level, because the 86 Act doesn't help with it on any view. The 96 Convention, if I'm right about what every other state that's opined on the matter, how it interprets it, doesn't help. In this particular case, of course, Mr. Justice Peel, whilst accepting that a bare return order falls outside the scope of the Family Law Act, decided that given the way in which this application was worded, given that effectively it sought care and or control or contact, substantively fell within the terms of section 11A or 11D. And because, going back to the point of application, habitual residence, his lordship found, was in this country, the court had jurisdiction. And we'll just concluding with Justice Peel, paragraphs 44-45 set out that his lordship doesn't opine on the appropriate date between two contracting states, although having accepted the handbook and Lagarde, it must be the same. But it says, it seems to me where the other country, Libya, is a non-contracting state. The second part of Lagarde is right. If which residence lies in England at the date of trial before me, Article 5 is operative, and on any view, England retains jurisdiction. If, however, between issue and hearing is transferred to Libya, then Article 5 ceased to apply, and national law became operative. It follows on the second scenario, either date of hearing, jurisdiction, Libya, jurisdiction is then governed by domestic law. Cumulatively, those sections provide the court has jurisdiction if his lordship sets out what I think hitherto has been uncontroversial, at least post A&A. That, we say, is, forgive me, the approach also taken, certainly so far as the relevant date for Article 5 purposes of habitual residence being determined, by Mr. Justice Cobb in Re-NH, by Mr. Justice Roberts, that was in August 21, in JC and PC, by Mr. Justice MacDonald in both the Warrington case and the Hackney case, and Mr. Justice Peel in H&R and the Embassy of the State of Libya. we further, oh my lord, perhaps I should pick up my skeleton again on this point. Point to the European Court of Justice case of CC and VO, in which, when determining the import of the transfer of permanent residence and Article 1 of the Brussels II revised regulation, came to the conclusion that a retention of jurisdiction, if the move was from a Brussels state to a non-Brussels Hague state, would constitute a breach of the Hague state's duties under Article 5. So the clearest possible decision in that case, that the CJEU takes the view that jurisdiction passes as certainly within Hague states as a residence passes. And interjecting there, that seems to be the reason why Brussels states, I was going to say simply, but Brussels states accept the CJEU decision as C, C and VO as representing the accurate description of Hague law. And of course, every Brussels state is also a Hague state. The Lord's...
Were you taking, is this CC against VO?
Lord, yes.
Because the decision in that actually is based on the wording of the, in part, on the wording of the Brussels IIa regulation, Article 61.
Well, Lord, yes.
And does it have any more, I mean, I don't think you've taken it to us, but it's on page 280, paragraphs really 30 to 33. That's a bit further. It doesn't really contain any analysis of beyond 61A.
Well, it does at paragraph 42.
42.
42.
Yes.
In, we would say, clear terms, and terms which in our agreed note in relation to the way in which other Hague states have approached these issues, which I think is a separate document, with which we burden my lords, was at paragraph 4 of that.
What these are all talking about is states that have jurisdiction and lose it. They're not talking about states that don't have jurisdiction and acquire it.
And well, Article 5.2.
That's just an observation. And they haven't addressed the consequences of a state not having jurisdiction at the beginning of proceedings, but acquiring it during the course of those proceedings. They're looking at, you have jurisdiction, the child's habitual residence moves from your state during the course of proceedings, and without, as I say, much reasoning, saying that that then jurisdiction moves away from you. And I appreciate
At any rate, if the second state is a party to the convention.
at any rate if the second state is a party to the convention. But they haven't factored into it as I say, the consequences of, sorry to come back to it, but the points made by Mr. Justice Lieven as to the unsatisfactory nature of a court acquiring jurisdiction during the course of proceedings, and it didn't have it at the beginning.
Well, no, they haven't. But if the plain reading accepted by, just taking my lord to the countries, Slovak Republic, Germany, France, etc., when Austria said the same, that a country loses it, then it follows that another country acquires it, unless transfer of jurisdiction, retention of jurisdiction provisions under the convention operate. But unsatisfactory though it may be, that's the situation.
Well, I'm not sure that's a good enough answer,
Well,
because Mrs Justice even has identified very child unfriendly consequence of that. That parents don't know, a child doesn't know which state has jurisdiction to deal with issues, and can suddenly find during the course of proceedings, many months down the road, jurisdiction being lost or gained. And that's not a very child-friendly, purposive approach to the impact of the scheme.
Well, that's the black letter consequence of there being no perpetuatio fori and the plain words of Article 5.2. And the black letter approach is then potentially softened by Article 9, which is exactly, of course, I mean, taking the Derbyshire case as an example, Her Ladyship decided it would be unsatisfactory to leave the question of habitual residence until later in the day, but went on to find that the children, Spanish children, present in this country, were not habitually resident here. So the black letter response to Hague would be to say, we have no jurisdiction, you have it, Spain. Her Ladyship accepted that was the consequence of what she said, but having conducted effectively a forum evaluation and coming to the view that England was better placed, she made an Article 9 request of Spain that the proceedings, the jurisdiction, be transferred from Spain to England. But even on that analysis, it's unsatisfactory. We have no idea, I'm not in that case, how long it will take Spain to decide whether, after the exchange of views that's mandated, whether it will cede jurisdiction. So it may be days or weeks or months down the line that the English court finds out that despite its request in relation to children who are living here, it has no jurisdiction over them. And the consequence, of course, of Mrs Leaven's approach in that case, deciding to fix habitual residence where it is. Let's say it takes a year for Spain to say that these children in English foster care, that Spain won't cede jurisdiction in relation to them. They will undoubtedly be habitually resident here by then. But notwithstanding that, on Her Ladyship's approach, she won't have jurisdiction over them. They'll be subject to the jurisdiction of a Spanish court. So, whichever way one cuts the particular problem, it's unsatisfactory when jurisdiction is claimed by different states, contracting or not. The convention puts in place a way of dealing with it, but we would say it's as clear as it can be. So I've cited the English cases. My Lord, I imagine my Lord Justice Moylan, who noted that we had missed an Irish decision in relation to Article 5, which I sent in yesterday. I hope my Lords have received it, in which the courts of Northern Ireland come to the same conclusion in relation to Article 5. And I've taken my court to the CJEU decision on the same point. Looking at the Australian cases, though most of them, as my Lord says, engage principally with the statute that was put in place in order to give effect to Australia's obligations under Article 5 in the Hague Convention. The Lord may have seen in the Bennett case that I took the court to earlier by Nina Lewis, that looking at Lagarde and the handbook as a means to interpret the statute giving effect to the same provision, Bennett J came to the same conclusion. In any event, says paragraph 185.
that says the section 111 CD.
Yes,
So it's dealing with the domestic.
it is. But Lord, that's the case in which I took you to. Bennett J. having used the Lagarde and handbook, Lagarde Reform Handbook, as a means to interpret the convention, which is the route by which she came to interpret, if all is right, the domestic legislation that gives rise to this. So our point, first of all, is that on a plain reading of Articles 5, 1 and 2, unsatisfactory though it may be in some cases, satisfactory in other cases, jurisdiction moves with the acquisition of habitual residence in a new contracting state, and Article 5 jurisdiction ceases with the acquisition of habitual residence in a non-contracting state. Apart from Mrs Justice Arbuthnot and an overture remark in the Mrs Justice Williams case, all of the English jurisprudence agrees with that. The CJEU agree with that. The various EU states that we've referred to agree with that. The Austrian case, the Supreme Court of Austria, came to the conclusion, according to 5.1 of the Convention, international jurisdiction depends on the habitual residence of the minor. As the principle of peculiarity authority does not apply to the Convention, international jurisdiction may lapse even during any admissible proceedings that have been brought. And so we say that add to that the Lagarde report, which explains why Article 5 looks as it does, an explanatory handbook, which, whilst with a different status, gives you the bird's eye view of what every other, what the consensus is among contracting states. And there can only be one conclusion in relation to Article 5. Given that Lagarde and the handbook both explicitly deal with the situation, A, when habitual residence changes from state A to a contracting state and B to a non-contracting state, and sets out what happens in each circumstance. We say it is difficult to conceive why there is a different response in Hague terms. The difference, of course, comes in that if it's a contracting state to which the child moves, then jurisdiction moves with it unless there is a transfer back of jurisdiction. But to protect a child in most cases, if the transfer is to a non-Hague state, then domestic laws, domestic provision applies. Our domestic provision is unusual because it is a combination of the 86 Act, which I've described, how others have described it, and then the, many would say, less than satisfactory nationality-based parents' patriarch jurisdiction. Other jurisdictions deal with a residual legislation very differently. And there's no reason why Britain couldn't do that, but she hasn't. But we say that can't affect the way in which the domestic courts interpret the international convention. Put another way, if we said otherwise, and if it applied both to convention and non-convention cases, we would be an outlier. But we would also be creating the scenario in which we would create conflict of jurisdiction in a way which would cause difficulties with partner states. So, for example, if Mrs Justice Arbuthnot had decided that the Spanish children were, at the date of issue, habitually resident in this country, let's say they'd gone to Spain from this country, they'd only been there for a short while, and let's say in X months' time, the Spanish court said they're habitually resident in Spain, then there would be an active conflict, which the entire purpose of the convention is intended to prevent.
I understand that point as regards contracting states. Can you run the argument as regards a non-contracting state?
Well, Lord, as I said at the outset, and quoted the handbook and the Lagarde, the convention is intended to create a single whole regime for cases as between contracting states. But as part of that, it creates Article 5, which doesn't differentiate in relation to non-perpetuatio fori in relation to contracting and non-contracting states. So if I'm right, and I claim no particular knowledge, but I rely on all those other judgments, all those other states. If I'm right that Article 5 acts in that way, and if I'm right that Lagarde and the handbook accurately describe what happens when a child moves to a non-contracting state, then if this court is contemplating retaining jurisdiction because the change of habitual residence occurred mid-proceedings to a non-contracting state, there's no reason, based on interpretation of what we're told by the founders or the commentators or the interpreters of the convention, to allow a different approach when it's to a contracting state. So that to fix...
Sorry, I don't understand that last bit. I understood that the guard was quite clear that where you move from a contracting state to a non-contracting state, nothing stands in the way of the contracting state retaining jurisdiction under its domestic law.
Yes.
Right.
But it can only do that through its domestic law,
Right.
not by somehow extending Article 5. So it will force back on the Family Law Act. Which creates the unsatisfactory result of having to look at habitual residence at the date of seisin rather than decision. And that is how, for example, in the Peel J case, notwithstanding there having been a transfer of habitual residence to Libya, yet the English court retained jurisdiction because His Lordship said it's a 1.1d order that's been applied for. And applying the FLA, at the point of application, the court had jurisdiction. So no problem. But His Lordship didn't do it by saying, because children in relation to whom we had an Article 5 jurisdiction have moved elsewhere, because it's non-contracting, we will somehow purport to retain jurisdiction under Hague. So that's the analysis on my reading in both of the McDonald J cases and the Roberts J case and the Peel J case.
Your example in respect of Spain and England probably doesn't work because of Article 13. In other words, proceedings couldn't start in Spain just so long as there were proceedings in England undetermined.
My lord, yes. But there would still, yes. But you'd have England and Spain applying completely different rules as to whether proceedings, whether jurisdiction existed, and whether they were entitled to exercise it. Well, I'm not sure there's much more to say in relation to Article 5. We've set out what we say in relation to the way in which it came into being and the almost entirely consistent way in which it's been interpreted in relation to both contracting and non-contracting.
When you say consistent, yes, okay. By implication that you lose jurisdiction. I don't think any of the cases referred as to actually determine the relevant date for the purposes of determining jurisdiction. Again, coming back to the argument that you start proceedings, you may not have jurisdiction, but you may acquire it. And the consequences of that in terms of Article 5.
Well, by definition, that would involve the child at that stage being present in and becoming habitual resident in for the first time a new state. Well, by necessary implication, looking at the Austrian case, having said that jurisdiction can lapse according to Article 5.2 of the Convention, this is the case if the child moves their HR to another contracting state, as jurisdiction is based on this. So 5.2 gives consequence of jurisdiction lapsing because it's then acquired in the new jurisdiction, the new state. Article 5.2, subject to Article 7, in case of a change of residence, a habitual resident from another contracting state, the authorities of the state of the new habitual residence have jurisdiction. Some laws. There are the examples of a child losing habitual residence that I've taken you to. There are the examples, for example, the care cases of children from non-contracting states acquiring habitual residence in this country and that founding jurisdiction. No, I don't think there are any cases in relation to the incoming court giving a judgment. But then that's perhaps not surprising, given the relative scarcity with which this convention is used.
I appreciate you running out of time, but just finally, in paragraph 410 of the Practical Handbook, which deals with change of habitual residence from one contracting state to another, just uses the word, this explanatory report suggests the principle that perpetuatio fora doesn't apply, and jurisdiction will therefore move. Suggest, where it does occur, consideration might be given to the use of transfer of jurisdiction provisions. It's not resounding endorsement of the position you say is clear.
Well, perhaps not. The handbook doesn't purport to undertake the roundup of the way in which Hague is interpreted around the world, or even within, for example, the CJEU. But my lord, it doesn't say.
But all I'm saying is, if it was as clear as you submit it is, I would have thought we wouldn't have seen that wording in paragraph 4.10. Suggests that.
Well, I can't answer that, given that.
And anyway, we're not within 4.10, we're within 4.11, which is move from a contracting state to a non-contracting state. The question is whether it's during or before the commencement of proceedings.
Well, there's no maybe in 411, where the child's habitual residence changes from a contracting state to non-contracting state during proceedings for a measure of protection. The principle of perpetuatio fori also does not apply. So if one's looking to the wording of the handbook to discern the confidence with which one can make or disagree with any assertion, so far as this situation is concerned, it's clear. But we wouldn't go that far. We'd say one can look to the guard, but also look, as we say, to the other jurisdictions.
But if the child was habitually resident in England and Wales on the date of the application in this case, then, pursuant to Section 3 of the Family Law Act, this court has and retains jurisdiction.
If a Section 11A or 1 with the order was asked for, which it wasn't. And that's the A and A distinction. And that's the PLJ H&R distinction. And again, obtuse though it may be, but trying to navigate sections 11A, B, C, and D is a difficult exercise for anybody.
Where does the judge say that in her judgment?
And so in which it's
where does Mrs Justice Arbuthnot say what is being sought is not an order within the scope of the Family Law Act?
Page 65, paragraph 123.
Sorry, paragraph.
The discussion starts at paragraph 123.
Right.
And then cites the Supreme Court in A&A at paragraphs 128 and 129. Including at paragraph 28, the Supreme Court's conclusion that the bare return order sought under the inherent jurisdiction is neither 11A nor 11D, and therefore not covered by Section 2.
The court actually decided that a return order could be within 11A, but wasn't in that case.
Well, depending on whether it's made under the Children Act or under the inherent jurisdiction, which are different proceedings with different application procedures.
So, as I read 132 to 134, if her other findings were right, none of this matters, but Professor George said in oral argument that the application for the inward return order was in effect an application for contact. This, during the hearing, was the first time that question was raised. Because of this, it wasn't fully argued. You're saying, well, too bad. The wrong type of order was applied for on the 23rd of June, so the court had no jurisdiction. It might otherwise have had if an order for contact had been expressly applied for.
Well, I think two things. First of all, that
Well, I think that is what you're saying.
that's what we're saying, if there would otherwise have been jurisdiction, which there wouldn't.
Yes, quite.
Yes. And attempts to soften the impact of the hard distinction between a Section 11D and 11A order or not, one sees made in the PLJ decision, where the application having explicitly incorporated requests for contact under the inherent jurisdiction, it was held to fall within 11D. My Lord, so on the one hand, my Lord says that is our approach to this, but that's also the solution to the more general problem, which is that if the right application is made and the retention is in or the removal is to a non-convention country, then that brings the relevant date scuttling forward to the date of application, which, as we say in most cases, will give the disgruntled applicant locus to seek the order he or she wants. In this particular case, on the basis of an agency's findings, it wouldn't actually have made a difference because jurisdiction didn't exist pursuant to either presence, obviously, or habitual residence at either the date of application or at the date of the ultimate decision.
And as to that, what were her reasons for holding that even on the 23rd of June, child was habitually resident in Zambia?
Well, they come in the section to which Mr. Devereux has already taken you. Having set out the law, we would say, in a way beyond reproach, the leadership deals with the evidence from paragraphs 28 through to 42, and then her conclusions in relation to habitual residence from paragraphs 43 and following. And my lord, moving to the wrong ground of appeal now, but for sure we accept this section could be fuller, could have been differently worded, but we fall back on the points I've made about the experience of the judge, immaculate self-direction as to the law, having heard the evidence, and in fact, in these relatively few paragraphs, quite how many individual factual points are made. I began my address after lunch today by reminding my lords of the other factors about this family, this mother, and this child that tie them to Zambia. I reminded the court of how much was done in fact to create this situation, this scenario before the move to Zambia. If the court is to be looking at the precise situation of the child rather than the melee about them, and to the circumstances of the parents and carers, only with a view to informing the situation of the child, then we say that there is more than enough here to justify her ladyship's conclusion. The Lord sees at paragraph 43, her ladyship reminded herself that 12 months when arriving in Zambia, 16 months by the date of application. So a hugely significant period of time in the course of her short life. Her ladyship looked at, in fact, the only real factors that can assist a court with reference to determining the degree of integration, settlement, stability in a particular area, given that at her age, many of the other factors wouldn't have taken place. And it's of huge relevance, we say, that this was a place, and these were people, and these were surroundings with which the child was already well familiar. I understand that the point was put by Moylan Judy Miss Ullman to her ladyship. The rhetorical question was asked, what more could be done to demonstrate the settlement, the integration of a child, a baby, in a particular area? It's hard to see what else there could be, given that everything was provided for her, everything she knew was there, her primary carer was there, all those factors were there, in circumstances where I set out what took place before that. So it comes really to the degree to which her ladyship should have looked backwards to England, running the risk, of course, of the disqualified factor 8 in Hayden Jay's list playing too significant a role. This was an examination of a very young child's day-to-day lived experience in a particular place, and one in which her ladyship pointed out all the factors which suggested being settled, but also, and I referred to this with reference to my friend's silo criticism, paragraph 50, for example, my lords see that it isn't a one-sided exposition. Her ladyship looks at the impact on her finding of a unilateral change in habitual residence or residence from England and Wales to Zambia, finds the lack of consent, and says, as can be seen from below. One has to import, I would say, into this linear judgment, because it has to be linear, the findings which follow from there. And her ladyship's correct assertion that it was a significant factor to be weighed in the balance. Of course, the way in which the weight to be given to these factors, we are told by appellate courts, are matters for first instance judges. And this experienced full-time High Court judge did just that, and settled on the conclusion that habitual residents had passed from England to Zambia. And in relation to paragraph 51, to which the law Justice Moylan referred, and on which Maloney Friend understandably sees that it could look as though her ladyship was in some way importing a simplified test, we would say that can make no sense when a High Court judge has given an immaculate self-direction in relation to the law that spans several pages, that deals with what has to be looked at, but simply, by way of shorthand, finishes off a section in this way. She's told the reader what principle she's applying and what she's looking for. She's then told the reader what facts she considers relevant in her determination, including the fact of non-consent. And then she concludes that habitual residence has, by the relevant date, passed to Zambia.
If you go to paragraph 121, the judge repeats what she says in paragraph 51. I have found that she had achieved some degree of integration and therefore she was habitually resident in Zambia. Simplified test?
Well, yes, if those words are taken to be the exact test that Lish was applying.
Well, that's not the test, you accept that?
Yeah, I do. Well, I point to it being
Is there any ground we haven't covered?
Well, only all of Article 7.
Right.
Which I can do relatively quickly. My Lord, we set out our argument in relation to ground 3 relatively fully from pages 18 of our skeleton, following on from that. I can distill, but then my Lords will give this due consideration in due course. Distill our arguments to a number of propositions. The first is this. As I've endeavoured to argue, the Convention provides a complete scheme as between contracted states. And that in itself represents, without great specificity that it's doing so, reason not to conclude that it is designed to apply extra conventionally. We point to Lord Justice Snowden's suggestion that one of the fundamental purposes of the convention is to settle disputes intra-conventionally, and that this interpretation of Article 7 isn't required for that. We point to the examples given in the practical handbook aimed to assist the practitioner in relation to how Article 7 potential conflicts would be determined, and note that none of them includes a non-Hague 96 state. The question so far as the authors of the handbook are concerned, what impact if it's a Hague 96 state which isn't a Hague 80 state, or a 96 state which is a Hague 80 state? And we would say that it's clear from the report, the handbook, and other sources that this provision is aimed, and the agreement on it is aimed to complement the 1980 provisions. My Lords, the CJEU in the SS and MCP case considered whether, in the context of Article 10 of the Brussels II revised regulation, that article, which Lords Bean and Snowden will know, or may know, relates to the consequences of abduction in Brussels terms, asked itself the question whether, this is on a referral from this country, whether Article 10 vested the court of the jurisdiction from which a child was abducted with ongoing jurisdiction in the event of abduction to a non-member state country, and clearly decided that it didn't. If I may, I'll just take my lords briefly to paragraph 46 on page 269. Now, I readily concede that this deals with Article 10 of the regulation rather than Article 7 of the Convention. But we would say that those final sentences are equally relevant. Finally, consequently, Article 10 doesn't justify indefinite retention of jurisdiction by the courts of the member state where the child was habitually resident before his or her wrongful removal or retention when the child has been abducted to a third state. And paragraph 47, we say, represents an interpretative principle as relevant to European regulations as it is to Hague Conventions, which is that a special ground of jurisdiction must be interpreted restrictively. And paragraph 55, one sees further exposition that because the escape provisions of Article 10 are worded in the way that they were, then there's a possibility of effectively indefinite retention of jurisdiction. And I'll come on to this, but query, what does Article 7 mean? Insofar as it relates, or insofar as it is said to relate, to abduction to or retention in a non-member state.
And that's Article 10 focuses on a period of 1 year after the abduction.
Yes. Well, as does Article 7.
In Article 10 does not justify indefinite retention of jurisdiction.
Well, it would, because the provisions are tied to member states. So Article 10, the escape provision, could never be realised if the abduction was to a non-member state.
Oh, I see.
Sorry, yes, it's non-member state.
Right.
That was because of the wording of Article 10.
Yes, my lord.
But that wouldn't apply if state in Article 7 is viewed as any state.
It
Then
wouldn't.
you would have the 1 year, as my lord has referred to.
Yes, although one would then have the difficulty of interpreting what the return application meant, and the difficulty of working out how Article 7.3 ties member states in with a freestanding state in Article 7.1.
Yeah, all I'm pointing out is the reasoning behind the Court of Justice's conclusion in respect to Article 10 do not apply to Article 7.
Well, not fully, we concede. It's an analogous provision, and one still has the difficulty.
Would the same problem arise if state in Article 7 is always construed as contracting state? In other words, there would be perpetual jurisdiction if jurisdiction was not acquired by anything other than a contracting state.
Well, it would do, but of course, we say that in any event, the package of jurisdictional provisions has to be looked together as a complete whole, as we're continually told. And Article 7 is explicitly tied in to and by Article 5.2. Article 7 is first mentioned with reference to the proviso on the rule that would otherwise apply of non perpetio fori, i.e. jurisdiction passing with habitual residence. And so looked at from from that end of the telescope, we say Article 7 is clearly intended to be the restriction on what would otherwise be the case of jurisdiction passing with abduction to retention in a contracting state, rather than to all circumstances, including when it is to or within a non-member state. Well, the 7.3 provision makes little sense if one is assuming that 7.1 is supposed to be any state, not simply a contracting state. But 7.3 is supposed to be what happens in one of the two scenarios. It is extraordinary that we don't see it recorded in those terms. And well, we point to the consequence of the interpretation that Moylan puts on Article 7. Within the Convention, the consequence makes perfect sense. The new state, which would otherwise acquire on an agreed basis jurisdiction, doesn't do until certain provisos are satisfied. So there's no conflict. It's a provision which A, avoids conflict, and B, prevents an abductor from taking advantage of his or her abduction or retention if it changes habitual residence. If it purports to keep jurisdiction in a non-convention case, it does the opposite. So just as this case, we see, and Lord asked me about this, another country with no obligations contractually, internationally, either to this country or to the Hague Conference, the Hague Collection of States generally, exercising jurisdiction. And what will then happen? That court exercises jurisdiction, goes on to do so. This court makes orders which aren't recognisable, which aren't enforceable in that country. So it creates that conflict. But then, if Article 7, the conditions apply to Zambia, then when 12 months comes to pass, assuming the child's settled, then all of a sudden the English court will cease to have jurisdiction. So nothing would have been served by it. Litigation would have been proceeding on two different fronts, one of which is the place in which the child isn't habitually resident, so that the whole doctrine of proximity is not complied with. So we say, looking at all of the different factors, it can't readily be said that it was within the contemplation of the Hague Conference this would apply extra contractually. And we point to the fact that no other state that anyone's found has said that it does so apply. My Lords, we set out, I won't go through them, various potential scenarios on different interpretations in our skeleton. We point to the fact that the request for return in section 7.1b being or the non-existence, the non-ongoing existence of which being a factor for a prerequisite for jurisdiction to pass makes little sense in the context of a non-96 convention or non-80 convention case. And in fact, the predominance of interpretation seems to be that that refers to a Hague 1980 return application. And we say that none of these problems arise if the court interprets the convention in the way we say, but equally, none of the dangers or mischiefs arise in the vast majority of cases where the abduction to or retention in state is either a 96 convention state or a 1980 abduction convention state or a non-contracting state, provided that at the point of application in England, habitual residence hadn't passed. And so, unsatisfactory though it might be in a small minority of cases, it is a tiny minority in which the so-called problem would arise. And again, that can't be a reason for this court, we respectfully submit, to interpret Article 7 in a way which may be exorbitant insofar as the intentions of the Convention were concerned, and would almost certainly, as far as our collective research has gone, be outlying in relation to all of the other Convention states, and still more when, as we say in the majority of cases, the problem won't arise anyway, because there are other factors at play. And going back, for example, to Australia, if that small minority of cases represent a problem, then they should be dealt with, as they have in the Australian statutes and many other statutes, by a rather more coherent set of national jurisdictional provisions, insofar as they relate either to a nationality-based jurisdiction or an extra-conventional, say, abduction-based jurisdiction. But to try to solve the problem by interpreting Article 7 in that way, we said would be problematic for the reasons that we have given. Well, may I turn my back, please?
Yes, of course.
Well, I don't think I need to take my lords to this case specifically. It's in our skeleton, it's in my own friend's skeleton. It's the case of Re J, in which one reads about the distinction between inherent jurisdiction being exercised in the different ways. Other than referring my lord back to that, I don't think I need to take my lord to it specifically.
Thank you very much,
Thank you.
Mr. Tyler. Deborah, of course, no need to repeat anything, but
No.
if you would like to make a brief reply.
A brief reply indeed, Lords, and I will try not to repeat anything. A couple of points. The first is that it's plain that for the protection of children generally, and indeed the protection of this child in particular, we need a jurisdictional framework that is simple, workable, and child-focused and protects children. And the dance that we've done throughout the day reveals probably quite clearly that, that the current interrelationship of mechanisms is very far from that. The second point I make is that, of course, the 1996 Hague Convention has not been considered by this court at any point before today, nor is it, so far as I can establish, being considered by any other appellate court. The third point is that there is an obvious attraction, which, if I'm permitted to, I would adopt, of Lord Justice Snowden's route map, particularly the fact that it's suggested that the convention may properly only apply as between convention states, and where the position isn't as between convention states, one simply goes to the domestic law under section 1, 2 and 3 of the Family Law Act. The fourth point that I want to make is to just revert very quickly and simply to page 507 of the authorities bundle, please, and to look again. It may assist, it may not, I don't know, but to look again at the practical handbook, and particularly on page 527, paragraphs 4.8 to 4.11. And it seems clear that the commentary there reveals that the critical point is that proceedings have already begun prior to the change of a child's habitual residence. So particularly see paragraph 4.9, which speaks of the continuing jurisdiction. Should be remembered that a change of the habitual residence of the child does not terminate any measures already taken. It might be thought that if the measures had been taken, that there would have been jurisdiction to take the measures. And in a similar way,
look at 4.10 during pending proceedings, it's referred to in 4.11. Again, the critical aspect there is that proceedings are already ongoing.
Well, the assumption seems to be that there's only one final hearing at which you have to decide habitual residence, and that, with respect, defies logic, because there can be many occasions during the course of proceedings when the court will have to make orders.
Indeed.
As you say,
indeed.
Interim care, contact, or whatever. And the suggestion seems to be that at every hearing the court has to repeat its jurisdiction analysis.
A further fifth point is that I made a reference this morning to a case of Mr. Justice Baker. I've distributed it to your clerks. I'm not going to waste the court's time referring to it in detail now, but it relates to the point that Lord Justice Moylan raised as to what the correct interpretation is of section 2(1)(a). So when it says the court in England and Wales shall not make a section 1(1)(a) order with respect to a child unless it has jurisdiction under the Hague Convention.
What's the name of that case?
It's called FA and JR. The citation is 2018 381 FAM, but it deals with that point and it may be of assistance. A further point that we wish to emphasize is, if my learned friend is right in his assessment of Article 5, we ask, perhaps a little too rhetorically, when indeed would section 3(1)(a) be invoked? And when the question was posed rightly by the court, my learned friend, after pausing, seemed to indicate that there wouldn't really be an occasion when he could identify that. A further point, and I'm coming to the end of these points, is we've noted my learned friend's proper concession that in relation to the assessment of habitual residence, Mrs Justice Arbuthnot appeared to apply what might be generously described as a rather simplified test, and I mean apply. There's a world of a difference between reciting at the beginning of judgment a set of principles and then applying them. And she applies, as my learned friend rightly points out, concedes what might be described as a simplified test, and he further concedes that she could have given fuller and better reasons and analysis. But that, of course, doesn't detract from our significant challenge as to the factors that she didn't bring into account, and the fact that although she refers in a shorthand manner to the fact that habitual residence would have changed before the father's application in June, she doesn't set out with any clarity at all which factors she has found of particular importance in relation to the June assessment and which she finds of importance in relation to the later assessment in November. And it's plain from the reading of the evidence, inevitably, that there are different factual matters that the mother would be able to invoke relating to the first date of assessment than the second date of assessment. Those are our points, save for one final one. It's important, and the court has this point because Lord Justice Snowden has raised it, but it's important to emphasize that the scheme of the convention and the objectives and purpose of it are very different from the scheme of the Brussels regulation. The intention, amongst others, was a harmonization of family law throughout the European sphere, and that was to some extent successful. But caution has to be had, in my submission, of simply transplanting the learning, for example, of the Court of Justice of the European Union relating to provisions in the European regulation to interpreting the provisions of this convention. And there are occasions when our own Supreme Court, for example, in the case of J, Morocco, have cautioned that very thing. So don't simply, my final permitted word of caution, don't simply accept that what the Court of Justice say necessarily and properly transplants across into any interpretation of the 1996 Convention. Those are our points in reply.
Thank you very much, Mr. Devereux. Our thanks both to Mr. Devereux and Mr. Tyler, who presented oral submissions with great skill, and to Professor George, Ms. Altman, and the backup teams who contributed to the written argument and the preparation of the case, which was immaculate. We will reserve judgment. We will send out a draft to Council in the usual way. 2 points to make about that. They'll be very well known to Council. The first is that the draft is sent out for correction of typos and other obvious factual errors, not for re-argument of the case. And second, that it's subject to the confidentiality obligations identified by the Master of the Rolls and the Counsel General for Wales case. Having said that, we will try to get it to you without undue delay, but it certainly won't be before Easter. Thank you all very much.